Good afternoon and welcome to Realty Coffee Talk. My name is Tahir Qureshi. I'm a fellow of Real Estate Institute of Canada, broker of record for City Realty Inc. brokerage. I'm the host. Today we have a very special topic, the consequences of a failed real estate deal. The goal of Realty Coffee Talk is to create connectivity, to increase awareness, building consumer confidence in real estate, and promote good ethics and business practices. I practice in the province of Ontario, therefore we talk about businesses in Ontario. Anyone have any question? After the presentation, I'm going to introduce Kinza Heather. She's a barrister, solicitor, and notary public in Toronto, and she practiced law. She's going to be our guest speaker. And I'm very glad that she able to join. After the conversation, we're going to have a Q&A session. Please feel free to ask questions, but make sure when someone is speaking, you turn off, you put on a mute, and then we can continue. So welcome, Kinza. This is tahir. I would like to ask you to introduce yourself a little bit about yourself. Who is Kinza Heather?
Sure. Thank you so much for having me. As you mentioned, my name is Kinza Heather, and I am a lawyer here in Toronto. I primarily practice real estate law. I did my articles a few years ago in the Ministry of the Attorney General, and then I slowly moved into private practice. So I mostly, as I mentioned, do real estate law, but I also practice in wills and estates, family law, and a lot of these laws actually go in conjunction with each other because, for example, if there's a separation happening, then the property is sold, or if somebody passes away, then their property needs to get down through their estate. So a lot of these laws are actually like tied very closely together. But primarily today, our topic is going to be on the APS agreement itself. And I think that's about me.
All right, wonderful. So basically in Ontario, we have Ontario Real Estate Association that created a form. I'm going to talk about the freehold agreement of purchase and sale Form 100, which is a standard use. There are condominium, there are parcel title land, and many other ones. We're going to talk about the basic freehold agreement of purchase and sale Form 100, which is used by all trade association. So help us out giving an understanding about the agreement of purchase sale. When you are creating an agreement of purchase sale, what is expected, or what is the understanding of this agreement? Is parties involved and buying and selling and a commitment being made? So there are two questions together actually. Understanding the agreement, what is the agreement of purchase and sale? Number two is commitment and obligation of the buyer and seller. So let's talk about understanding of agreement of purchase and sale.
Yes. So the agreement of purchase and sale, and I'll use a short form APS, it's extremely, extremely important. People, you may sign many documents afterwards before closing, but the APS itself is the absolute most important one. And especially like, for example, if you're bill
we have Kinza, we have a little problem with your voice.
All of this furniture, etc. But if it's not in the APS, it's not part of the deal.
Kinza, your voice was breaking, so I don't know. Can you check it to make sure your voice is okay in terms of your system?
Hello?
Yeah, we missed that. Can you repeat again, Kinza?
Yes, sure. Can you hear me now?
Yes.
Okay. I'm not sure what's going on. I'm in Zoom meetings all day and it doesn't disconnect. I'm not sure. But okay, so as I was saying, like the APS is the absolute most important contract in most people's lives. So many times when you're going through buying or selling a home, the realtors or the sellers, they say a lot of things to market the home. But if it's not in the APS, then it's not part of the deal. So they may say, you know, the hot water tank is already bought out. You can have all of this furniture in the home, etc. But if it's not in that APS contract itself, then it's not going to be a part of the deal. And in particular, like a lot of them are, of course, generic, but Schedule B is an attachment to the APS, as many of us know. And anything and everything that you may want to include has to be listed in there. You cannot rely later on the goodwill of people, or that they told me this will happen. If it's not listed in there, you're not going to be able to get it, at least not easily.
So basically, the agreement of purchase sale is a document that is committed and creating obligation between buyer and seller.
Absolutely.
There is a consideration involved with that, and this is a very serious document. It creates a legal obligation and is enforceable under the law to implement it, and it comes to you guys to implement it and do everything that needs to be done. And the conditions needs to be improved. And we have a form, this 100 plus, we use Schedule A and B. B
Yes.
is normally the schedule that is used by the seller agent when they list the property. Those are the conditions defined, including the real estate trust account, Section 27 of REBA, that talks about how the trust deposit will be handled. So basically, both buyer and sellers are really making commitment to sell the property, for example, in this case, and buy a property with this consideration of the money they have agreed.
Mm-hmm.
So what are how the consideration will play a big role in agreement of purchase and sale?
So the way the law of contract works is that if there's no consideration, you're not that you haven't promised anything in return for something, then it's not a real contract. And that's why sometimes in a lot of cases, people sign the APS, but then they don't provide the deposit, saying, oh, well, I haven't provided a deposit. There's no consideration, meaning, okay, I can back out. But that's actually not correct. And it's actually how a lot of people end up being in default of an APS, which has severe, severe consequences. Once you sign the APS, the consideration in this case is the promise to pay. The promise to pay is like, you don't have to even provide the check. The promise to pay is the consideration, which makes it a valid contract in of itself.
So you already jumped into the stuff that I already have a little
don't
bit
provide
on the part.
it, and which
Kinza, your voice is breaking. Kinza, your voice is breaking.
oh no.
Yeah.
You know what?
Do I have a problem, or you all feel something is happening here?
Is it only on my end?
It's good
Yes.
now.
Jared, can you
Okay.
hear her?
Yeah, it's good now. I can hear her.
Okay, all right, thanks. So you are saying is that when an agreement has been negotiated between buyer and seller
Mhm.
and is properly executed, and
Correct.
if the buyer decide not to give deposit, if they feel that maybe their realtor didn't do a good job, or maybe they change their mind, and that situation, and it's a firm deal. As you know, we have a bidding war going on right now, shortage
Exactly.
of supply. So that means they're committed to that
Yes.
agreement, regardless of they have not given the deposit. Is that
Yes.
my understanding?
The consideration in this case is not necessarily just the deposit given, it's the promise to pay. So the promise to pay, once you've signed that contract, you've already given that consideration, which means it's a valid contract in and of itself. And if you do not provide the deposit now, some people think that, oh, that means the deal is canceled because I just didn't provide it. No, it means you have breached the APS now, and all of the consequences that the severe ones, all of them will apply and can apply.
So in most cases, sometimes, you know, the one is a consideration of obviously a deposit. It
Yeah.
happened in our brokerage one or two times, but we were able to sell the property to a higher.
Mhm.
And because of shortage of supply, and this is a seller's market, seller doesn't want to get entangled itself with the litigation and other stuff.
Right.
But the potential is there, and therefore there are many buyers waiting to buy the property. So it may not be a good situation here that sellers say, okay, I don't want to waste my time. Let's go to the next guy. But what will happen if it is a buyer's market and seller has a difficulty selling his property when it's sold, and then someone backs out? In that situation, what will happen then?
Yes, there are severe consequences for not fulfilling your obligations of the APS. One, of course, the deposit itself. If they've provided it, then that deposit can be forfeited. But if they have not, then they can be sued for that full amount of the deposit. On top of that, say the seller were forced to then relist it, try and sell it again, but they weren't able to get it at the same high price. They had to sell it for lower. Any difference in price that they just lost, and any of the costs that it may have been associated with reselling, all of that can also be included. And so I was actually just reading an article the other day when in 2017 and 2018, this type of thing started happening widespreadly, like in a lot, I think it was in the dozens and dozens where people were defaulting on the APS. And finally after COVID, the cases are coming in. The highest, I don't want to like quote it wrong, but one of the consequences was 1
I think I'm having a problem with your voice. Gerald, do you feel the same thing?
Okay, I think I will reconnect again using a different internet then.
Okay, go ahead. You please.
Yeah, give me one moment.
Okay, all right. So maybe we can continue our conversation. So far, I think there's a little problem with the communication here. Important that the topic is because we are in a position where buyer has refused to give deposit, and a realtor end up sending a message that my buyer doesn't want to close the deal. She thinks that the price is high. He didn't do a good job. Sometimes they don't mention that, but they tell you off the record instead of on the record. And eventually buyer refused to pay and deposits, and they think they're off the hook. Yes, go ahead, Isabel.
Yes, I'm wondering, question, this is happening in Canada, right?
Yeah. Yes.
Yeah. This situation is in Canada because, for example, right here in New York, and I'm talking about New York because I know in Florida, for example, the agents are allowed to prepare the contracts themselves, and it's totally different. We are not allowed to prepare the contracts, but we are allowed to make the meet of mind and share the information for an attorney. But at a point that if anything happens, like if the buyer wants to back off, the buyer back off and the deal is dead. That's it. We don't.
Isabel,
We don't
okay.
proceed.
So we'll talk about that later on. Kinza, are you okay? Kinza,
Hello?
are you okay now?
Yes, I believe I just switched my Wi-Fi. Can everyone hear me a bit better now?
Yes, very clear.
Okay, perfect.
So we were there on the consideration in terms of liability commitment in the agreement of purchase and sale. And there are consequences for not, we're going to talk about those as we move forward. So let's assume agreement is very comprehensive. Just for the viewers, that we create an Ontario Real Estate Association, especially because our jurisdiction is Ontario. Our board and also Ontario Real Estate, she created a forum. It's a standard forum. It has a lots of information there, but information that is very special or specific is either identified in Schedule A or Schedule B that overrides the pre-printed conditions so in there. So, and in part of it, let's assume that a buyer refused to give deposit, but there are some deliverance in the agreement that the seller has promised to do that. So how we go about those deliverances? For example, providing a site survey, floor planning, or some environmental report if it's environmental issues. So how we go about it if the realtor says buyer doesn't want it, but you might end up, a seller might end up pursuing a legal action against a buyer. How we deal with that deliverable that the seller has to make a delivery to the buyer?
Yes. So these issues generally actually are negotiated with the lawyers themselves. And oftentimes nowadays, there are conditions where if you obtain title insurance, then it can actually waive the requirement to like environmental reports, surveys, any other really like some of the other certificates that are sometimes requested. So those are not necessarily needed anymore. And oftentimes, not only are they not needed, sometimes they're just not available. For example, the survey, if there hasn't been a survey done in the past few decades, then that can be circumvented by getting title insurance.
So what step that a listing agent who is representing a seller would be doing or assisting the seller to approach a lawyer if they want to pursue that approach?
Yes.
At
Well,
what time?
one simple thing that you can do is, of course, just add that into either Schedule A or Schedule B, because then that overrides the pre-written contract.
In our section 21 of the APS is talk about tendering. Any tender of documents or money here under may be made upon seller or buyer or their respective lawyers on the day set for completion. Money shall be tendered with the funds drawn on a lawyer's trust account, blah, blah, blah. And this is also talk about time limits to make sure that things are done. So if there is a situation where a buyer had refused and seller want to pursue that, so is it not something done by the lawyer who has that? Because the lawyer are not involved at that stage because it's the beginning, the agreement of purchase and sales was formed or accepted, and buyer refused to give. So at what stage a realtor can suggest to their client they pursue or they can approach a lawyer to get their opinion?
Yes. So as soon as one side has breached the agreement, that releases the other side from having to fulfill their part of it. So as soon as the buyer has not provided the deposit, now the seller is not obligated to provide the status certificate or the searches or any of the other information that they're supposed to automatically. Like the contract is breached.
Yeah. In normal cases, we have some conditions, financing condition, mortgage condition, and a home inspection, just to name a few. And when we have gone through a normal process with the conditional offer, negotiating the deal, and then those conditions were removed during that period, and then they're waiting to close, all those period. And how the time will play, how is the time of the essence, like how critical the time and dates are in our offer when we are negotiating the deal. We have irrevocable time and offer has to be accepted, and then we also have a completion date is there. So how critical are these timelines when you are negotiating or helping a client to negotiate an agreement of purchase and sale?
Extremely, extremely, extremely. 1 second off means that you did not close on time. And sometimes if the other party is, generous, then they can simply extend it at no cost. But at other times, like people are buying and selling on the same day, that 1 minute can cost the other side thousands and thousands of dollars, which they may put on you. And in fact, 1 minute late means you did not close the deal. It does not mean that you closed it late. It means you breached it. You breached the agreement of purchase and sale. You were supposed to close by 6 p.m. And if you did not, then the same remedies and consequences that we were mentioning earlier in terms of forfeited the deposit, client or the sellers can resell and sue you for whatever the difference is. All of those again still apply, even if it's 1 minute late.
Now, the most important thing, our Ontario Regulation 580/05 is Code of Conduct Ethics for under Real Estate Business Broker Act, talks about the transmittal of agreement of purchase and sale to buyer and sellers, all the parties. How significant is that a negotiated agreement of purchase and sale is transmitted to either party, the party who made the offer or the party who accepted it, and acknowledgement?
Sorry, I'm not understanding the question. Like, how important is it to provide the final APS to the clients?
Yes, transmitting the agreement, a negotiated agreement to buyer and seller, so both agrees, they know that within the time frame that was specified in the agreement purchase and sale, that they have received the executed and accepted copy. Because
it's extremely important.
It's very important because Ontario our code of conduct, it creates a obligation on the part of the registrants to make sure these are delivered, and it's very specified in the Code of Conduct Regulation 580/05 of REBA. So, and because what happened is, if somebody don't have a copy or it was not delivered to it, what happened then?
Well, quite frankly, then if they're not fulfilling any of the obligations that would have been in the APS, simply because they didn't know and they didn't receive it, now that will fall on their realtor or the real estate agent, and it's their professional obligation and responsibility to make sure that their clients have received it and they understand their obligations. So that, it's a huge error on the part of the realtor in that case, where they would probably be getting a RICO complaint.
Yeah. Now, here is sometime that in our agreement of purchase and sale, there is a place where they put the email or phone number or fax number of the cooperating broker or listing broker to make sure this document is transmitted. So once the buyer and seller signs that, that means receiving a notice to a buyer agent or to the seller's agent is actually acknowledgement of the notice?
Yes, because then it's the agent's responsibility and it's the onus is on them to then provide it to their clients. Giving it to them means you've provided it to the other side.
Now, the other important part of the agreement of purchase is that the acknowledgement, which is specified on page 5 of the APS form 100, where I have noticed that sometimes people miss the confirmation of acceptance on the agreement of purchase and sale. They sign the acknowledgement, everything. How do you view that if they have failed to sign or data stamp confirmation of acceptance?
I view that as a small error that generally can get rectified. I mention it to the realtors and have them go back and make sure that all of the signatures are completed. I actually haven't come across that myself, to be honest with you. And well, I had once, but they had already had it signed and they were able to provide it to me. So luckily I haven't dealt with something like that. But if the signature box is there, it needs to get signed for sure.
Because I have some questions on this because I have talked. It says on the form, confirmation of acceptance, notwithstanding anything contained herein to the contrary, I confirm this agreement with all changes, both typed and written, was finally accepted by the parties at this time on this day of this month of this year
Yes.
and signed. So
Yes.
if they don't, for example, in my opinion, I'm asking, is it enforceable under the law if it's not been accepted and certified and accepted?
That it's a little bit more of a gray area where you would still probably go to litigation and have it decided there. But yes, there's a lot of then a little bit more of an onus to prove that they did agree, that they did sign, that it's a binding contract. Because oftentimes, as you guys all know, is that it goes back and forth and many things are struck out and everyone puts their initial on the side. But you cannot always tell whether the initial on this side is for this struck out line or this one or this one. So having that final acknowledgement signed means they've accepted the final version and not just the previous one. So, I mean, usually in like not having that signed, you can still go back in all of the emails to see which one they had signed. But again, it's just a little bit more of a hassle or a burden to then prove in court. Most likely the seller or whoever did not breach would still end up successful, but of course cannot say for sure.
Yeah, for clarity and to make sure that the terms are both agreed by both parties, especially if they have acknowledged it, the intent is there to accept it, correct? But there
Correct.
is a process they have to go through unnecessarily through litigation if there is a dispute.
Exactly.
The reason I'm saying to you is because if this error is made in this pandemic environment where the supply is very short and people are bidding on this is a good excuse for seller not to sell the property and create a problem in this case.
It's a bit of an issue though, because if the buyer really, really wanted that property, they could probably try and sue the seller for it as well, saying that the intent was there, that was a minor mistake, and that they did have a binding APS. So now then if the seller has sold it to someone else, perhaps they would be in breach. So it could go either way. And I would not use that missing signature as a reason for then considering the APS to just be invalid.
All right, that's a debatable, and obviously
it is debatable. It's a little risky
because it's not been accepted in a sense but it creates a vague situation, ambiguity,
there's some
in a sense
ambiguity there.
Which create a potential a dispute or a litigation process. And when a seller is trying to sell the property, they don't want to go through this process of this. Make sure everybody pay attention. So viewers are, especially real estate professional, when you are processing your agreement of purchase sale, make sure if you are your client is the accepting the offer, please make sure there is a date, time stamp on it and they have signed it and
Absolutely.
acknowledge it, because this is very, very important.
Yes.
So let's go back to I think we already covered the dealing representative breach of agreement. So now there are various scenarios of breach of agreements. So what are the most commonly breach of agreement purchase sale that you experience as a lawyer, because you specialize in real estate? So
Yes.
can you share with us? I can point out
the most typical and common and obvious one is that the funds did not come in time. They were not able to provide the funds on the closing date. And that could be for a variety of reasons. Most likely the mortgage has somehow been canceled or just was not approved in time. And so they did not get the funds in time. And quite frankly, I want to mention point 12 as well, like with where the appraised value comes lower than the agreement of purchase and sales negotiated price, because they kind of go hand in hand in that oftentimes, especially now when we're having these bidding wars, people will bid and bid and bid and inflate the price to a point where the bank might not see it at that value. And so they might have their 20% of that price point and they're expecting the rest to come from their mortgage. But now the bank has not appraised it for that value. They appraised it for, say, 200,000 less than that. And so that means now the difference in that you also have to come up with on closing date. You will not get a mortgage for that full amount. You'll get it for the 200,000 less value version. And because of that, I mean, of course, I don't know about most of you, but a lot of people don't have 200,000 extra lying around for this type of thing. And that's where the breach ends up happening.
Thank you very much. I think you addressed a couple of things that I have in my mind, which it was listed on my checklist. So the reason we are talking about this subject is that when real estate profession is involved with the buyer to make sure they do their due diligence, and same thing apply for the sellers and same thing apply for the buyer, particularly the buyer. And if it's a first-time home buyer, then definitely is a lot more scrutiny and a lot of more education needs to be done. The important thing is to have a conversation that we have conversation with the buyer to prepare the buyer for the transaction and guiding them. You create a team of professionals, means you have a lawyer in your team, you have a mortgage broker lender in your team, you have a home inspector, you have an appraiser. All those people are part of the team to make a transaction. My experience is lots of people go to the lawyer at the time of closing when there is a issue, when they're drafting the agreement of purchase and sale, and especially conditions that are very important for the particular property. They don't consult with the lawyer. And the lawyers are very happy, they get paid for the small work, close the deal, that's it, right? But they should use them. Ask them, can you craft us, help us to write the condition in the agreement of purchase and sale to make sure we don't get into trouble if it's a complex issue or anything.
Yes, and once it's signed and once we're getting towards closing and you go to the lawyer, you tell them, hey, they told me this, it's not in the APS. There's nothing that can be done at that point. It's too late. You definitely need to consult or get the advice before the APS is signed, while it's getting drafted. At that point, it's one, of course, you should have your mortgage and your funds kind of in order. Make sure that at least like a neighborhood appraisal is completed. Just have something, because the last minute surprises are disastrous. I've been seeing them way too often lately.
Yeah, this is very, very important that when you are meeting a client and you have a brainstorming session, put your thinking cap and discuss all process of buying a real estate.
Yes.
A beautiful home for the family. So you go step by step and you tell them how this process will work. You need to get your mortgage approval or pre-approval before even you do the offer. You also have a lined up the inspector. Sometimes you have to do inspection before putting an offer, because of what's happening is in the bidding war is the preemptive offers. I was talking to someone and they put preemptive offer. Therefore, they are already verified, because potentially, if you put a firm offer without any condition, you might end up once you move into the house, maybe you need some appliances to be changed, or maybe roof needs to be changed, or furnaces or windows are leaking, things like that. And you need to have your budget prepared and you have funding set aside for that purpose. So therefore, this is critical. Second thing is to make sure you have a contingency funds, just in case, keeping in mind the appraised value is lower. The bank given you right to give the commitment to give you the money, but unless they have given you the money is not there. Therefore, you have to be very prepared for that. So that's why you need to have a financing condition in your agreement of purchase and sale to make sure you have a firm commitment and make sure you have provided them a proper document for financing. I am a licensed principal broker with the Canada Express Mortgage Inc., license number 13241, just to let you know that you have to have accurate information to the lender and satisfy their requirement during the due diligence periods to make sure majority of the issues are related to financing in closing, most cases, unless there is some very limited issues in terms of condition of the property, unless there is a major disclosure that was not made. And that's another issue we're going to talk about, disclosure. So this is why it's very, very important to work with a team, and realtor should connect with all the time with all the team to make sure everybody is doing their part, just doing the follow-up. Now, what is the obligation of the lender if they made a commitment, they give you direction, but they decided not to give money? So
Yeah,
how do you educate your client? Because now we have a mutual client, realtor client, and also a lawyer client. So how we deal with that?
Yes, and in fact, if you would see majority of the lenders' documents and their approvals, they always write in there that they can refuse to lend or they can back out at any point for any reason. And so it is a huge risk. And in fact, I've seen a lot of clients where they have an approval, it's ready, and then a few days before closing, they will do something to change their financial status, meaning something like they will go and lease a car. And suddenly that completely changes their debt to income ratio, and their mortgage gets refused based on that. And now for closing, which they were completely ready and perfectly fine for, now they cannot close. So at any point before closing, even if you have the approval in hand, that does not mean you have the funds in hand the way you just mentioned. You have to make sure you satisfy all of the conditions, even up until the second of closing date.
Wow, that's put us a lot of pressure on everyone to make sure that you are looking after all the scenarios. And this is why it's very, very important for real estate professional to remain connected with the lender, with the buyer and all lawyers and everyone to make sure everything is progress simultaneously. Signing an agreement for purchase sale doesn't mean that it's going to close unless we follow up things. And basically, we are there to help you as our legal representative of our client to make sure the agreement of purchase is implemented according to the in good spirit and faith, which has been negotiated. And therefore, if you need any help, I remember recently we have a transaction where a condominium insurance was expired before closing. So the lawyer sent us a notification, and I have other real estate person in our office to reach out to the realtor and the buyer to make sure it's provided through the system. And lawyer also approached them, and we got resolved that problem. So small, because lender wants to make sure their money is guaranteed because the condition of the property, correct?
Absolutely. And for example, I mean, they have good reason for if after the closing, the next day, God forbid, the building were to go on fire, what is the lender going to go after? There's absolutely nothing. So of course, every little thing, every condition needs to be satisfied to the T.
Now, what about can you tell us a little bit about the title insurance, just to have a clarity for what kind of protection the entire government has intended in this title insurance, because it's kind of getting a little bit expensive sometime, and depending on the value and approximately, you can give us an idea about this and give some clarity.
Yeah, for sure. So it is, well, there's two options. One, you can get title insurance, or two, there's an alternative, which actually ends up being more expensive, which is the one where you hire a surveyor, get a survey, make sure you get all the certificates from the city, tax certificate, environmental, fire department, zoning department. There's a few others. So there's either that option, which is very cumbersome, or the other option that the banks will allow is just get title insurance. And it does seem pricey, but it's actually the cheaper of the two options. And what title insurance generally covers is things like if property taxes, well, one thing that it covers is that anything that you would have discovered from option A, from all of those zoning searches and certificates, anything that you might have discovered there and you discover after the fact, all of those issues are going to now get covered because they are protecting you from doing all of that work. And so what that usually means is that, say there was arrears in property taxes, arrears in water bills. And what is actually more significant is that mostly for homes, if the boundary line of your home is for some reason not what you received, for example, a neighbor has built their fence on your property. So then to fight those things out, because you would have discovered that if you had ordered a survey, but because you didn't have to, because title insurance covered you. Now, if you discovered it after the fact, they will be able to reimburse you and also involve themselves in litigation on your behalf.
Well, I'm going to talk about, thank you, the role of a registrant and obligation under REBA 2002. Just for a simple clarity, we have Real Estate Business Broker Act, and Real Estate Council of Ontario is a regulator. I suggest to all registrants in the province of Ontario to read the Ontario Regulation 580-05 under REBA. It's called Code of Ethics. The title of this chapter is Obligation of Registrants. So there are section 1 to 53 in this, and I highly recommend to all real estate professional, when you are performing duties under the act, to read this obligation. So you have understanding of it. You can go to reco.on.ca. It talks about many topics in there, keeping fairness and honest, keeping the best interest of your client in mind, conscientious and competent services, section 5, dealing with other registrants, because when you know that your buyer is not going to go through it, but he's putting the offer, make sure that you don't do something because you really putting the seller's agent in trouble, because maybe your offer is accepted and then you know that that would be the case, but you didn't disclose that. We have to be honest and professional, and we have an accurate representation, and you don't want to do anything become unprofessional, unbecoming of a real estate professional, because you're violating the REBA. So I'm just suggesting all real estate professional, please read real estate REBA, a Code of Ethics Regulation, Ontario Regulation 580/05 Code of Ethics. Now we're going to go back to the final question before we ask the Q&A. Very short one. Potential of litigation and financial liability. So in case there is a breach of agreement, it doesn't matter at this stage, is a small breach of contract is a breach of contract, correct?
Yeah, correct.
So what are the potential litigation and standard cost associated with dealing with a residential deal?
In terms of litigation, if there's a breach?
Yes.
So first and foremost, like if it's the seller who is the recipient, or no, I'll go backwards. If the buyer is the one that has breached, then I guess in this day and age, it's actually easier for the seller to just relist and resell to someone else, keep the deposit. And if they had to sell for lower by any chance, then they can also sue for any of that difference. And in fact, because of the insane prices nowadays, I think I was mentioning earlier, but it might have gotten cut off due to the bad Wi-Fi. But I was reading about the highest award that was given for a breach like this. It's above $1 million. So not being able to fulfill your obligations of the APS can have huge lifetime ramifications. For most people, their deposit is their life savings. So not only is that gone, but any other expense that the seller had to incur from reselling it due to the breach, then that is also, well, that not automatically, but they can sue and also get that added on into there. And then from the other side, if the seller is breaching, so they decided not to provide vacant possession or anything like that, then again, the buyer also is able to sue them. It's actually quite difficult to sue them for specific performance, meaning having to sue them in order to get that specific house most of the time, unless you're able to show that that particular home had a very significant meaning for the buyers and that an alternative home will not be suitable, then you might be able to get it. But otherwise, they would also be able to get some type of monetary compensation.
So basically, you're telling us it's kind of time consuming and expensive as well for the.
Extremely. Lawyers will be happy, but but the clients themselves, they will be out a lot of money.
So I'm going to ask you a question is that since a buyer has refused to close, for example,
Mhm.
what happens is the seller wants to sue. Is he going to sue the listing agent also, or the brokerage, or just the buyer? What is the normal practice?
Likely the buyer. I mean, they can add on everyone because just because you win doesn't mean you can actually collect afterwards. So even though you're awarded a damages for $1 million, it's very difficult to collect the $1 million. The other side doesn't have it. So that's why oftentimes they will sue anyone and everyone on the other side, that in the hopes that someone will have deep pockets and someone will be there to be able to collect.
So basically, it is a kind of expensive or extensive in terms of reputation damage.
Very.
Reputation, if a realtor professional is involved, this is why we have to be very careful about what we do, how we do it. We have a legal obligation. We're licensed. We're professional. Consumer trust us, and we're supposed to provide competent, honest professional with great integrity our services, so they are taken care of and they have a successful acquisition of their property, home sweet home. Therefore, it's very, very important that we work very hard, and because we have to put food on the table because of a successful transaction. We don't get paid until a transaction is successfully completed. So this is therefore is very, very important that we pay attention to the details. So I really say thank you very much, Kinza, for your conversation with us about consequences of a failed real estate deal. So I'm going to open up the Q&A now. I'm going to start with Gerald. He's a FRI instructor with REIC in Edmonton. So Gerald, you have any question for Kinza?
Well, thank you very much, Tahir. You read my mind. One thing you said earlier that I have two questions if I have the time. The first one you'd mentioned earlier, I found it surprising that, well, okay, technically, like as you mentioned, a minute past closing, you're in default of your contract. Are people actually enforcing that? Because I would think if you're making every effort, but of course circumstances get in the way, right? You're making the effort. Surely it would be considered, I'm not sure the legal term, but you're making your best efforts. I don't know.
While like I am of that mind that we can be forgiving of that, but it truly does depend on the client. Like if the client, and it also really depends on the circumstances. As I was mentioning, like sometimes they have a buy and sell on the same day. So they were relying on being able to sell their property, get the funds that same day, and use them for their own purchase. So the fact that it became a minute late meant they are now defaulting on their own purchase too, which then they have a little bit less mercy.
Wow, yeah, that's, I guess the troubles, it's been a few years since we've had those kind of troubles in Alberta, although we've had our days with that. And the second thing I wanted to comment on, and it's more of a general comment than anything, but I'm a little surprised how the marketplace, the banks, everybody seems to be gravitating more towards title insurance than we call them in Alberta, we call surveys real property reports.
Yeah. Mhm.
And I remember some years ago, lawyers were saying, better to have the real property report, the survey, so you know what you're dealing with and you can deal with it. Plus with the title insurance, there's always that, it's insurance, so there's always a chance it could be denied if the insurer thinks that you might have known about something and were trying to hide it or should have known about something. So I don't know if you have any comments on that, but it just seems everyone's gravitating towards title insurance.
Yes.
Yeah.
Generally, it's mostly, I feel, because title insurance is the cheaper option. Hiring a surveyor and doing all of the reports takes a lot more time, and not to mention then the lawyer fees are of course increased as well because it's a lot more effort. But it's not that difficult to prove that they did not know, mostly because if they didn't have the report, there's no way to know. So if you don't order the report, you don't know, and therefore it's quite easy to just know after the fact once a problem comes to light.
I'll have to always, that's what I'm always tough on. I just like, no, get that report, get that survey. And, my friend Tahir, thank you. That's all I have for questions.
Thank you very much, Rashid. But do you have any questions?
Yeah, Kinza, thank you very much for your educational thoughts, and whatever you were saying was meaningful. My question relates to the concept of breach of contract. And I believe, like Tahir Saab was discussing breach of contract, and as you also alluded to it, that it is kind of obvious and apparent that, okay, somebody did not pay for it, so that's a breach. But my question actually relates to the anticipatory breach. For that matter, for the anticipatory breach, you, like lawyers, they have to do the dichotomy or the dissect the whole case, and then you dig out what is the anticipatory breach, and you just kind of pick and choose perhaps, or maybe the judge will choose. Who will choose, the lawyer or the judge?
So sometimes the anticipatory breach is very, very obvious. That's why you have to be very careful when you're alleging something like that. But oftentimes when you do it, it's literally because the seller has written, or a seller's lawyer has written in an email that we will not be able to close today. Can we get an extension? Something in of those along those lines. So that is like extremely hard to refute. Other than that, I mean, saying something like we might be able to close, we might not be able to, that's not enough. They can still come up with the funds by the cutoff time, which is 6 p.m. And if they do, they're still good to go. So, I mean, you're right in that like lawyers do have to do some dissecting of what's going on. But I would never use anything like said to me on the phone or just in regular conversation. It has to be, if I'm going to allege it, it will definitely be something very obvious that is written down in an email or a letter or a fax, something along those lines for sure.
So can I say that it's more of a question of semantics rather than the law? Is that something like that?
A little bit. I mean, of course, if they had told me over the phone, they have said it. But once it gets to litigation, it's all just a he said, she said at that point again. And so even though you may be in the right, it's so difficult to prove it that you're actually doing your client a disservice.
Yeah, that's what I think so. Thank you very much for the answer, though.
Thank you very much, Sab. Now I'm going to ask Lida, because she was talking about she's from New York. So Lida, it's your turn.
My turn?
Yes.
Okay, I'm not from New York. I'm from Kitchener-Waterloo, home of
sorry,
Blackberry.
sorry about that. Yeah, sorry, go ahead.
That's okay. No, I just wanted to know, just follow up with that question. Like, so then who handles that that issue now? Is it between lawyers, or do the realtors like deal with that?
The anticipatory breach?
Yeah.
No, then it would be the lawyers. It would be the lawyers. If there's a breach, that means they're not closing. And then you essentially go to the same options that we have when there's any other regular breach where, say, they didn't have, it's the exact same as if they didn't provide the funds on closing day or they didn't provide a deposit. So you have all of those same remedies again. So it could mean maybe the realtors are involved where the sellers want to relist, or it could mean that it's going to litigation, in which case then they're not involved and a lawyer would be involved. So it really depends on like which strategy the client wants to take moving forward.
Right.
But in general, anticipatory breach is like treated almost the same way as a regular breach.
So once I'm done the contract, the APS, everything's signed and sealed. Any changes to that, am I supposed to deal with them, or can I just send the issues to the lawyer for them to deal from one lawyer to the other lawyer?
What type of issues would you
like change of dates? They can't close. They want an extension.
So you're able to actually negotiate amongst yourselves. Like if it really depends on the clients, if they're agreeing to change the date, then there's no harm in that. But if the seller for sure is going to require maybe like amendments in the price, or they want rent or any of these kinds of things, then the lawyers can also deal with that.
Okay. Okay. Thanks.
No problem.
Okay, I just mentioned clause 8 of REBA, Ontario Regulation 580-05, that talk about services from others. So basically, we are licensed to practice in real estate. We can only give opinion and service related to real estate. Anything else, we have to reach out to the professionals of different competence and jurisdiction. The lawyers are the one. I think according to Ontario law, the lawyer or the legal clerk are the only one who can close the deal, correct? Is that my understanding?
Close the deal as in be able to register and
complete a transaction?
Yes. In fact, law clerks cannot do that as well. It has to be the lawyer's signature that goes onto the land registry system to be able to affect that.
Even for the private deal as well, correct?
Correct.
Because there is a title issue, there's still again the mortgage charge, there's issues that needs to be resolved. So
even if it's like a private cash deal, you would still need that signature on there.
Okay, fantastic. Barbara, are you there? You want to share something on your side before we end our program?
I'm here. However, thanks. Thanks, Keisha, for thanks for all the good information. However, I'm the only one in the office. So what happens? The phone keep ringing, so I had to kind of mute myself. So I was trying to listen with one ear and take care of the office at the same time. But thanks again for lots of good information. I got a lot out of it. Rashid asked some questions that I was able to, that you answered that I was thinking of. So, you did great. Lots of good information. Thank you so much.
Thank you very much. I'm gonna, Shirley, are you there, Shirley? Dana, are you there? Anyway, well, I just take this opportunity to thank our guest speaker, Kinza Heather, for spending some time with us and giving us a little bit of education and informing us how the legal matters are resolved when there is a consequences of a failed deal, what happen, or breach of an agreement happen. The best advice will be to reach out to your lawyer, get them to help you to mitigate. I do recommend that keep in mind the realtors are the first contact with buyer and seller. We have developed a very bonding relationship. Therefore, we are able to facilitate a negotiation, try to make sure if there is a time for amendment is required or anything that we can facilitate, please do that. Nothing stops you to have a consented amendment to the agreement of purchase and sale during or at the time of closing. If there is a cooperation on both sides, because of COVID, pandemic has created a lot of challenges for everyone. And I have seen in our Canadian industry, there's a lot of willingness to cooperate with each other to make sure we facilitate and have a good understanding that things can happen as long as they are reasonable. Also, make sure you have a good clauses written in your Schedule B to protect you and have the right to extend the time if you feel there is a potential for any delay because of closure of the office or bank not giving you money or so whatever reason. You always talk to the lawyer and get some clauses in there to protect your clients. It's very, very important. In terms of trust deposit, once you have money, we have done that, and you can forfeit the deposit if there's a clause in there in the agreement that if you fail to close on time, we're going to take away your funds. But again, there are protocols that you have to follow. It has to be mutual release or a court order. And you always need a lawyers to help you understand and make sure that guidance is there. Thank you very much for all of you participating, especially Kinza, Heather, for your participation. We hope to see you again some other program. Thank you for watching, and this program will be on YouTube uploaded, and you can watch it. Please subscribe my realtycoffeetalk.com. Visit there and subscribe my YouTube channel and help me to promote. This is all on volunteering basis. Thank you very much. We'll see you next episode of Realty Coffee Talk. Thank you. Thank you. Bye for now.
Take care, everyone.